staying with us. In case you're joining us right now, you're just in time for the big conversation here on KTN Prime. We're talking matters, land inheritance and succession. Our families are broken, the courts are full, and even morgues continue to hold dead Kenyans who've been killed or murdered on grounds of, rather, killings that are emanating from land tussles. This is despite laws that we have in place that highlight how we should go about inheritance and succession, from families to mothers to daughters to widows. What does the law say? How can we prevent the disputes that we have, the cases that we have in the corridors of justice, and the deaths that we continue to witness owing to unsettled land disputes here in the country? And to help me unpack and also help us understand and dissect these very crucial topic, a conversation that we indeed must have as a country, to my immediate right is Advocate George Kithi. A very good evening to you, sir.
Good evening, thank you.
Many thanks for making time.
Good meeting you.
Always a pleasure.
Thank you.
Okay. Also joining us this particular evening is Wakili Leah Kiguatha, who is a family lawyer. Leah, very good evening to you. Many thanks for making time.
Good evening. Thanks for having me.
Welcome. Now, ladies and gentlemen, Wakili, let me begin with you. Like I've said, we have laws, but this issue of land inheritance and succession is costing us lives, if we had to call it that. Families are fighting, they're in court, families are broken, widows being disinherited, daughters being disinherited, yet we have laws. Why are we still having all these tussles to begin with?
All right, thank you. Probably just to put in perspective is that succession is basically its own province of law that basically imbues the succeeding of property from the dead to those that are living legally. Meaning, therefore, that when a person is dead and had property in his possession or her possession, that must be succeeded through a court process that determines the heir or the person who then owns the property after the death of, or after the demise of the erstwhile owner of that property. Land has its own legal regime too. It's governed by its own laws, set of laws that govern proprietorship, its transfer and management. Now, the fusion of succession law with land is, of course, when a person dies but owned land, and that land has to be succeeded by the would-be living and would-be owners to succeed in that possession or proprietorship of the land. When that happens, there is therefore, it's not the Puritan law of succession of the land, and therefore you realize that land becomes a commodity for acquisition through the court process called succession. When that happens, there are a certain issues that must be met, called principles in law, that will govern the process of succeeding the possession of that land to those that were left behind, meaning the estate. Suffice it to say, therefore, that what law addresses is what then is written and confined to the text of the law, and the emotional part, the emotive element of the succession process, which means the property left behind, is a different issue not addressed by law. So the emotive element of the societal organization cannot be addressed by law. Law addresses the fault lines that need to be met and the principle that they put into place in order to succeed. So whether people lived in love or without it, whether they had good relationship or without good relationships, notwithstanding, the succession, the property needs to be succeeded as has been bestowed by law, or what law has casted as the proper way to succeed it. There are two ways in which it's done. Of course, those that die without any intention whatsoever on how the property will be managed after the death. meaning there's no will or any intention to bestow ownership to particular individuals or in what manner, but that those that document it and put it in writing or pronounce it in any other way that can be probably justified before court, such that then the property is available to the promise and intentions of those that owned it before but are dead. And therefore, that is the province of law as will be managed by the entire province of the law of succession under the Succession Act.
Okay, I'll come back to you in a moment because you've mentioned something really important. There are instances where families fight because at the end of the day, there was no will at all. Kigwetha, if I may come to you now, you're a family lawyer. I don't know whether you've dealt with such cases where there are tussles, about land and how it should be subdivided among members of the family, but there's no will in place. So how can someone go about that to begin with?
Yes, all the time. And to your question, to add to what George said, that one of the reasons we end up with these tussles is that lack of estate planning. When you don't make a plan, when you don't indicate, because you own the property, but although we are all headed, we all know where we are headed. We all know how this story will end. Mm-hmm. We are often reluctant because we don't know when we are going. So we are often reluctant to say what you want to happen to your property when you pass on. So a lack of estate planning, a lack of writing wills, and estate planning goes beyond wills. But one simple way to estate plan is to write a will. And it's not very common, it's not very popular. A lot of people don't write wills. So that's where you end up with disputes in families. Another thing is that I think societal expectations and what people expect. I think because we owned property communally for a long time, we therefore have a notion about who should get what, okay? And then we are shocked when we find out that the law says something else. We are shocked when we find out that your married sisters under law are allowed to inherit your father's estate. When, for example, if you were an only son or there was one or two sons, you lived all your life with the expectation that all this property is yours. And then when your father passes on or your mother passes on, you're shocked to find out that your siblings that you sort of feel you gave away or who went away are now entitled. And so you see, disputes coming out of that expectation that you were expecting. And then the law says something different from what you expected. So there's that issue of we don't estate plan, and then there's the issue of certain expectations that we have. We see sometimes when somebody dies and they have, there are many people saying, I depended on this person. So like the parents want the spouse to not have priority because they think, our person has died, the person has come back to us. They no longer belong to their spouse. And so you have all these tussles based on expectations. And then sometimes also when we estate plan, I think because of that communal and societal expectation and what expectations we had, I sometimes suspect that we don't think we challenge the plan, the person's plan. You write a will and people challenge your will because they may not think that you should, wewe ndio kusema, they don't think you're the one who should have said. They think that now that you're gone, let it go to the fastest or the person who is the craftiest. And so sometimes the people who are close to the deceased person are mourning, they are deep in shock, and yet there's somebody else going behind their back and planning, and either to challenge what the deceased person wanted, or they have expectations about what should happen with the property, which expectations may not be exactly what the law requires. So there are many, many factors that cause people to get into these disputes once somebody has passed on.
But maybe before I come to Advocate Keithy, when you talk about a will,
yes,
what makes a valid will? Mm-hmm. Because sometimes there's concern that this will is not valid. This one was had been doctored. We've had those particular allegations even in the current political circles. So what makes a valid will?
All right. So now there are two types of wills. Mm-hmm. There is a written will and there is an oral will, And a written will has to be in writing. The person doing the will must be of sound mind at the time that they are doing the will. It must be witnessed by 2 independent witnesses. These 2 independent witnesses must sign the will, and they must see the person writing the will signing the will or acknowledging that that is their signature. So that's a written will. For it to be valid, there has to be 2 independent witnesses, which means 2 witnesses who are not beneficiaries under the will.
Very important.
Yes, so recently I was witnessing a will, and it was so interesting that the witness said, I know being a witness means, when because you've called me as a witness, it means therefore that I'm not inheriting from you. She was telling her friend, don't call me as a witness, put me in the will. Because you see, the 2 witnesses must be independent. And so some of the problems we have is that the witnesses are the people who are benefiting, okay? So if your witness is a beneficiary, you then need 2 other independent witnesses to be independent people who are not benefiting from the will. And then also the person writing the will has to do it willingly. So that's a written will. There's also an oral will. Now, an oral will is when somebody speaks out and says, this is what I want. But this oral will has to also have 2 independent witnesses. All right? And the person making the oral will must not outlive the will by more than 3 months. So that oral will is only valid for 3 months. So when you come and say, oh, my father said this 10 years before he passed on, or my mother said this 7 years before she passed on, that's not an oral will. An oral will is only valid for 3 months, so that when you make the oral will, if on 4 months, 5 months later you're still alive, that will is no longer valid. So it's only for 3 months, unless you are in the armed forces or in the Navy and you're going out to fight in another country. Then we can look at your oral will 4 or 5 months after you've made it. Now, another thing about oral wills is that you cannot invalidate a written will, or you cannot revoke a written will with an oral will. I can't write a will with my 2 witnesses willingly, and then I write it down, and then people, after I pass on, people say, oh no, but she revoked that written will with an oral will. So when you have a written will, you cannot revoke it with an oral will, and there are very clear stipulations about an oral will, how long it's valid, and also remember that there has to be 2 independent witnesses. So it cannot be, I cannot come and say that George left me his estate in an oral will and I was the only witness. I cannot come and say that you left me, or the 2 of us, or George and I say you left us your estate and we are the only witnesses, that you left us your property and we are the only witnesses. There has to be 2 independent witnesses who are not beneficiaries under the will.
Pretty much. Wakili Kithi, if I may come to you now, she has highlighted important issues in regards to these wills. But one would ask, because we have cases where some children are not included in the will, or there's a spouse not included in the will, then the question would be, can someone legally write a will but exclude a child or a spouse for their own reasons? But legally speaking, can they do that?
Yeah, that's an important question, because it's probably one of the areas of litigation or disputes before court. In many facets of it, but within the confines that we've explained. When you write a will, you must know your beneficiaries. And you must include all of them. Now, because you've raised the issue of the children, you cannot disinherit your children. Now, children does not mean children with your wife, even if they're children without your wife, meaning children outside
wedlock.
Yes. So any child is entitled to inherit from your estate. Now, they don't have to inherit equally. It doesn't mean that if you give a car to someone and land to the other, you then must confine it to some equity of sorts or equality. It's your will, meaning what do you intend to bequeath to them when you're not there? So disinheritance is one of the reasons that one can use, or an applicant can use before court, who has been disenfranchised or discriminated against, or disinherited for that matter, to invalidate a will. Meaning, therefore, you can write a will, and if you exclude, for instance, your child who you don't like, or for whatever reason, did not work hard in school and the others worked hard in school, or you couldn't get along with, you cannot disinherit the child. Another issue is, most men do it. You got some children, or children outside your main line, family line, meaning your wife, and then you don't pronounce them throughout your life. You don't introduce them or associate them with your family, but you probably take care of them and support them out there. But then when you're writing the will, because remember, when you're writing the will, you're still a human person with the fear of probably your spouse or the environment you live in. You're still confined within the context of your life. If you die, of course, you are dead, and therefore you're gone. But when you're writing the will, you write the will while you live. And with the fear of probably your spouse, you do not mention the other children who are outside your wedlock. But probably they know, and their mother knows, or their mother knows and they don't know. So when there's that court issue for determination as to whether or not they should be inherited, the issue of the DNA aspect to prove parentage then becomes an issue for that comes up most of the time. Suffice it to say, therefore, that those that write wills, first, it's best if it is a secret. Only to the extent that it is witnessed, as my good colleague has said, it is witnessed by two independent people, but it ought to be a secret because it gives you the province and the latitude to put in the information that is legally required to be put, meaning don't disinherit your children. If you do, you'll be gone, but then you are inviting a dispute before court for invalidation of the will in the event that it is proved that you had disinherited or have not complied with the requirements of law, one of it being all your children must be inherited.
It brings two other different aspects, and maybe I'll start with one. If the person is dead, and now the DNA is done, and it is ascertained that indeed he or she was part of the family, was said by the person who's dead now, does the family of the deceased have the right to say, you're part of the family, but we are not giving you anything? What does the law say in terms of, if it is indeed ascertained that I am a son of the deceased, who determines the share that I will get? What does the law say in regards to that?
Well, first, it is illegal to distribute estate without the command of law or order of court. Meaning, therefore, that you cannot say this person is dead and we are distributing the property by sheer want of our desires, because an investigation of court must be made as to who deserves what at that time. That's why you have to go through a succession process. Number two is that you cannot arrogate a right of who gets what by agreeing and excluding the court process. So you must go before court and then agree before the court, so that the court then records that agreement as part of its order. The court order is the sanctity to whom then you can bequeath property. For instance, you can't transfer a dead person's car whose proprietary identity is the logbook into your name without the court saying so. Even if the right subsisted, it stops being a right to be succeeded if you do not go through the court process that commands that the logbook is changed into your name, and that is the constant with land and any other document. Okay. If a person is dead, in your example, and then there's a determination that apart from the family, another alien or another person is determined as part of the family, even in that context, you still, all of you, must go to court for the court to pronounce you as heirs by law and bona fide for that matter, and whether this person then inherits or disinherits. Let me add this. The person who is disinherited, notwithstanding that is a son of the